Attorney General Loretta Lynch is an American lawyer who served as the 83rd United States Attorney General under President Obama. She was the first African American woman to hold this office. She previously served as the U.S. Attorney for the Eastern District of New York from 1999 to 2001 and from 2010 to 2015. In July 2016, Attorney General Lynch announced the decision of the Justice Department to close the investigation into the use of a private email server by then presidential candidate Hillary Clinton. A long-standing advocate of criminal justice reform, she has dedicated much of her career to holding institutions, including police departments in New York and Chicago and around the country, to account. Thank you so much for joining us here today, Attorney General. It is an honor to be hosting you. I wanted to start off by talking about your early life. You grew up in North Carolina with your interest in the legal field sparked by watching local court proceedings alongside your father. Could you tell us about your family and your childhood and how they shaped you to become the person you are today?
Well, thank you so much, and thank you for having me. It is truly a pleasure to be here with the Oxford Union, an organization that has reached back through history and tradition until today to have the conversations that matter. And so I thank you for including me in the list of those with whom you are having a dialogue. My family really is everything to me. They are the core of my being. They are my support system. I gained a lot from my parents. My father is a retired Baptist minister. But I do believe he's a frustrated lawyer because he was always fighting for one cause or another. And when I was very young, he was very involved in local politics. I was actually born in North Carolina, as you noted, in the city of Greensboro. Greensboro, North Carolina was home to A&T University, which is one of the first places where student sit-ins began to protest desegregation. 4 college students started to go to the downtown Greensboro area and have a sit-in to protest the fact that they were not allowed to eat in segregated restaurants and diners. This protest movement started with young people, as most protest movements do, as most effective movements of change do. But it grew. It grew to cover the entire city. My father was a young minister at the time. My mother was a young teacher. And my father was one of 2 ministers in the city of Greensboro who opened his church to the protesters so they could have meetings on the weekends to organize and plan for the week. And I was very young. I was literally a toddler at the time. My older brother and I were very young, but he would take us to these meetings. And my dad always carried me on his shoulders and let my brother run around with us. And he always said he knew that we wouldn't necessarily remember the meetings, but he wanted us to be in a place where young people were making a difference and where they were speaking out against a very important issue, of course, Jim Crow laws and segregation. So that is the beginning. My father also tells me stories of my grandfather, who was also a minister, but a local farmer in eastern North Carolina. And by farmer, I actually mean sharecropper. My grandfather didn't own his land. And he and his sons, that's my father and his older brothers, would work for other farmers, usually white farmers. At the end of the season, they would get paid what they hoped would be a fair wage. So it was a very, very, very challenging economic situation. And you really were at the mercy of the white farmers for whom you worked. But my grandfather, in being a minister, was also a leader in the community and always believed not just in a higher power, but in a higher sense of justice. And my father tells a story that when he was a young boy in the 1930s, if African Americans would get in trouble with the law, and they knew they weren't going to get a fair trial, they knew they weren't going to get a fair hearing, and so often rather than stay and face either mob justice or an unfair trial, they would leave. They would literally flee the state and leave their families behind and go to the northern part of the country. And often my grandfather would hide those individuals under the floorboards in their very, very simple cabin. And my father remembers occasions when the sheriff would come by their home and ask my grandfather, his name was Augustus Claude Lynch. He would say, "Gus, have you seen so-and-so?" And my grandfather would say, "I haven't seen him lately." And so that's how he avoided all of this. So I was always struck by the fact that within this tremendously unfair system, the criminal justice system that day was also tremendously unfair to people of color. My grandfather found a way to bring a modicum of justice to people and also maintain actually a very positive relationship with the sheriff. whom as I grew older, I sort of was convinced that the sheriff probably knew what was going on and was actually letting it happen as well.
After this incredible childhood, you went on to study at Harvard, where you graduated with degrees in American law and in American literature and law. Could you tell us a bit about your time at an Ivy League university and what it was like being a Black woman at Harvard in the 1980s?
Well, I have to say, I was tremendously excited to go to Harvard. When I left high school in North Carolina, I wanted to spend time in a different part of the country. I wanted to meet people from different parts of the country and different countries also. I wanted a more cosmopolitan experience. North Carolina is a beautiful state. I still think of it as my home, but it is very homogenous, shall we say, and it does have the racial issues that I've mentioned. So I was very excited to go up north, as they say, and attend school. And I have to, and for the most part, I loved my experience there. But I think the biggest learning experience for me was learning that people are the same wherever you are. We all carry with us our own biases and prejudices. And I was actually somewhat shocked when I got to Harvard and was sitting with my freshman counselor going over my study plan and telling him how I wanted to major in English and what I wanted to focus on and the love of books and reading that I had. And he broke into my discourse with him and said, I'm happy to be your advisor because I have all the special cases. And I said, well, what do you mean? And he named a few of my freshman classmates. And he named a few of my classmates who had some physical disabilities, and one of my classmates who had visual impairment, who was blind. And I thought I was actually thunderstruck when I realized that he was actually putting me in the category of students who had some sort of disability. And I wish I could say that I had the perfect comeback and that I gave him the perfect set down and stormed out of his office. But the reality is I was so taken aback by that characterization that I didn't know what to say. I didn't know how to relate to him. And as you can imagine, he was not the most positive influence on my freshman year in college. Received very little advice and support from him and just got the requisite signatures that I did. But I was fortunate enough to meet professors and teaching assistants who saw a potential in me and saw in me a love of reading and learning and helped me explore different worlds of literature. I've always found, for me, growing up in the South, reading was the escape. You can go to a different world. You can meet different people. You can explore different cultures through books. And so having the luxury to study that at Harvard was truly a gift. But I was always very cognizant of the fact there was an overlay there of privilege, of a view that perhaps I didn't belong, not just me, perhaps women didn't belong. Harvard had become fully co-educational in the late 1970s. So while I was of a class of women who went to Harvard College, the women who were maybe a few years ahead of me had actually applied to Radcliffe College before the joining of both institutions fully. So you were always faced with people who seemed to be, to my surprise, threatened by my very existence and place on their campus. And sometimes you think you were coming from a place of privilege, and you certainly have a sense that you belong here. What is it about me that makes you feel so insecure? Perhaps you're looking at it from a sense that no one really is secure in their place in many of these institutions. And so that was one of the other messages that I took from that, is that we're all struggling. We're all struggling to find our way. We're struggling to find out who we are and where do we belong. And unfortunately for many people, the way in which they try and carve out a place for themselves is to deny a place to others.
After graduating, you spent a few years in the private sector, but then you began your career in government in the US Attorney's Office for the Eastern District of New York, working on cases in your early days of political corruption, among others. What are some of the cases that stand out to you from this time, and what did you learn from your early years in the public sector?
I've always enjoyed public service. I have loved working in a law firm as well. I find that that's a wonderful way to contribute to society. But when I was a young lawyer, I did feel the pull of public service. And for me, it came about after a series of particularly challenging weeks at my first law firm, and I was working very hard and working on some fascinating cases. And one Friday night, I was in my office late at night trying to get a memo done, and I literally passed out at my desk. Fortunately, there was a secretary with me who was able to help me overcome that event, but it made me start to think about what I was doing and why. You know, when you are a lawyer or in any capacity, of any field of law in this country or any other, you invest a great deal of yourself into your profession. You invest your time, your energy. And so I began to wonder, was I truly using my talents and my energy, such as it was, in the best possible capacity? And when I joined the U.S. Attorney's Office, it was important to me to be in a position where I could work on the protection of people. The lesson that I always took from the story that my dad told me about my grandfather was that for so many people in rural America, and even continuing to the present day, they don't feel that they have the protection of law enforcement. And that to me is not part of how my country should conduct itself. Equality under the law, equal justice under the law means that everyone gets the same protection, rich or poor, black or white. So it was important to me to be in a field that I could do that. I started out, like so many young lawyers, prosecuting the narcotics cases, but I soon began to work on cases involving violent crime. The federal laws in the U.S. allow us to prosecute crimes like murder and extortion on the federal level if they're part of a gang or organized crime. It's called racketeering. And I began to work on cases like that. And I began to truly see the impact of violent crime on people, the impact of the loss of a family member, the death of a family member, someone being killed on a family. And I spent a lot of time with the victims of crime, talking to them about what justice meant to them, about what a fair resolution would be to them. And it was quite eye-opening, because at the end of the day, you cannot bring their loved one back, but you can give them a process through which they see that their needs are acknowledged, that they are listened to, and they feel that someone is advocating on their behalf. And that has stayed with me throughout my career, both as a practicing prosecutor and also as I grew in the office and began to manage the U.S. Attorney's Office. I would have to say, though, that probably one of the cases that had the greatest impact on me would have been a case of police brutality that I prosecuted in the late 1990s. A Haitian immigrant named Abner Louima lived in New York with his family, young family, was out for a night at a nightclub. Violence broke out. Police came to break up the fight. Mr. Louima was wrongly arrested. Police thought that he had actually struck one of their own, and he had not. And it led to an event that changed not only his life, but changed New York City in some very, very important ways, and changed me in some very, very important ways. We worked on this case prosecuting the police officers who had both beaten Mr. Louima en route to the police station for processing, and then had brutalized him. They had literally taken him into the bathroom of the precinct and sodomized him with a broken broomstick. It's still very difficult to think of that happening to another human being, even with all that we have seen in recent years. But that case, more than any, I think, really honed my focus on the importance of making sure that all aspects of the criminal justice system were dealt with fairly, that there was accountability and transparency, not just for those that we prosecute on the streets, but for those of us who were entrusted with carrying out the prosecutions and law enforcement.
When you look back at these cases of police brutality 20 years later, do you think the conversation around police brutality has changed in any way?
It's changed in some significant ways. When we were prosecuting the Louima case, this is the late 1990s. I know that predates not only you and your classmates, but many people who will be listening to this podcast. We encountered a wave of disbelief. Mr. Louima, as I mentioned, had been brutalized by police officers, and the extent of his injuries weren't uncovered until he was taken to the hospital from the precinct because of the damage that he had suffered and the bleeding and the like. And when he first told his story to the nurses and tried to get greater attention to it, it was met with great disbelief. Now, the doctors and nurses saw the extent of his injuries and the numerous surgeries that were required to help him, so they knew that something terrible had occurred. But the fact that it had been it had happened at the hands of uniformed New York City police officers was something that was very, very hard for the public to swallow. It also illustrated the fact that police officers band together after the incident itself. For a period of the first few days, the officers who were involved came together and got their stories straight and put in official paperwork that described a very, very different scene, as you can imagine. So the conversation we were having initially was, yes, this actually did occur. So we see a major shift in conversation now, in that with the advent of viral videos, which I think tragically have shown us that in fact police brutality does occur, we now have a greater acceptance and understanding of the problems within policing in this country that lead to this kind of behavior. But that was a major, major hurdle for us. One way in which it has not changed is the difficulty in prosecuting these types of cases. When we were prosecuting the Loretta case, a number of officers had seen parts of what happened, but getting them to come forward and testify was extremely challenging. And we see that today. It's often referred to as the thin blue line, where officers come together to protect their own. And officers were very candid with us in private meetings, and they would say, I either heard about this incident or I saw parts of it, but I cannot testify. Please don't make me testify. They would beg us. And the fear that they expressed was that if they were labeled a rat, which is the term that is often used in US law enforcement for a cooperating witness or a snitch, that if they were ever on the street and needed backup in a dangerous situation, no other officers would come and support them. And sadly, officers confirmed to us that that's likely to be the case. This, more than anything, is one of the things that makes prosecuting these cases so difficult, because the people who are on the scene are literally afraid to come forward. That's beginning to shift a bit now. It, I think, has also been helped because the video evidence makes it much easier to come forward and corroborate as opposed to being the main witness coming forward with incriminating evidence against a fellow officer. But the biggest shift, I think, has occurred quite recently in this country. You know, when I began working on these issues after the Loretta case, we undertook an examination of the New York City Police Department, because the main question after the initial case, the main question in the criminal case, of course, is how could one human being do this to another? But on a larger level, the question that you have to ask is, why did uniformed New York City police officers feel that they could, in fact, brutalize a defendant in their custody and get away with it? What was the culture that led to those actions being considered acceptable by them? What was the disciplinary structure that led them to think that even if someone did come forward, a fellow officer, that nothing would happen to them? So we began to explore these issues, and of course we were met with tremendous resistance, not just from the police department, but really from citizens who have trouble believing that such an important force can in fact have layers and levels of corruption in it. That has continued to be the case over the years. I've continued to work on these issues throughout my time as a prosecutor and even in private practice. The recent weeks, however, with the death of George Floyd, have seen a shift in that attitude. More and more Americans, at least, are certainly recognizing that police brutality is a problem, and that it is a problem of police culture and police leadership, and not just a few bad apples. That is the most important shift in this conversation. It's recent, and I sincerely hope that it continues, because with this shift, we will begin to affect some real change in policing, at least in this country.
Before we go into talking a bit more about the George Floyd case specifically, I wanted to talk about the killing of Eric Garner in 2014, which you once again were faced with when you came back to your role under President Obama in 2010. Could you tell us about the role you played in the Eric Garner case and how you felt in 2019 upon finding out that the killers would not face federal prosecution?
You know, the Garner case was another tragedy that occurred, again, on video. Mr. Garner's death was captured on screen. It was replayed endlessly. I think, as I mentioned, that the advent of these viral videos has led to a shift in the conversation in America. But one thing that we have to always remember is that family members are watching a loved one literally die in front of their eyes. This is traumatic. It is incredibly difficult for a parent, a sibling, a child to see this over and over and over again. So when the case first occurred, I was, as you noted, still the U.S. attorney in Brooklyn, and we began to do the investigation concurrently with the Civil Rights Division, located in what we call Main Justice in Washington, D.C. And as is typically the case, we let the local prosecutors review the matter first and determine if they could bring local charges of assault or even homicide. I feel very strongly that the Department of Justice has an important role to play in these cases, but I feel just as strongly that local law enforcement must also be involved and hold officers accountable. In this case, there was no indictment at the local level of the officer or officers involved in this, and the federal investigation began right as I was moving down to Washington to become the Attorney General. And we, of course, ran into similar challenges that you always do in these cases: the reluctance of law enforcement to investigate their own, the challenges of trying to anticipate the defenses, the high bar that the federal statutes place on these cases. We were at the point of beginning to put the federal case into the grand jury when the administration turned over, and it was picked up by the current administration and ultimately dropped. I think that, again, I could not predict what would have happened had this case been fully vetted and fully investigated before a grand jury. Would they have handed down indictments or not? I certainly believe that there was a strong chance that they would have. But I think my greatest disappointment was at the length of time that it took to come to that resolution. You had a family in limbo for years. Now, you also had a police officer and his family in limbo for years. One of the challenges of these cases when you are the prosecutor is that you have to bring justice to both sides. You have to have a fair process and procedure for the putative defendant, but you also have to make sure that the victims' voices are heard. And in this case, I don't think the victims achieved the full measure of justice that they could have and should have.
Alongside police brutality, one of the many things that you dealt with in your role was also financial matters and the FIFA case. Could you tell us about the role you played in the investigation into senior FIFA officials, as a result of which 14 senior FIFA officials and executives were indicted, and ultimately President Sepp Blatter resigned?
The FIFA case was a fascinating endeavor. It began, again, when I was the U.S. attorney in Brooklyn, and it was led by an outstanding team of prosecutors and agents and investigators. And we began by looking into corruption in some of the merchandising arrangements there, and quickly realized the corruption ran all the way to the top of the FIFA organization, but also it extended into the various marketing organizations who were paying bribes in order to get access to the games, and also countries that were paying bribes in order to have the World Cup series landed in their country as well. It became a sprawling investigation. It was fascinating because it really did highlight what so many people had been saying about international soccer, which is a wonderful sport. That unfortunately the leaders of the organization, that the leaders of FIFA, had long since left their mandate to bring this sport to the world, the most popular sport in the world, by the way, and instead were using it to line their own pockets and enrich their friends and supporters. And I think it was so important to me and to the team because, sports are the way in which we teach our young people the fundamentals of life. We teach them about teamwork. We teach them about fairness. We teach them what it means to win with honor. We teach them how to lose with dignity and grace. We teach them how to work to achieve goals. And when you see the leaders of the organization that's in charge of the most popular sport in the world that touches so many young people turn away from these principles and instead make it about themselves and their personal enrichment, it's infuriating. It literally is infuriating. I know it was for many fans for many years. For us, we were able to look at how they were using the American financial markets to carry out this web of corrupt financial transactions. And it was very important for us to bring them to justice and to continue the investigations and bring them to justice as well. When you have a situation where money that is supposed to go towards setting up soccer fields in some of the poorest countries that we have instead goes into the pockets of the FIFA leaders so they can have yet another car, yet another airplane, something had to be done.
Turning now to your time as Attorney General of the United States. You were nominated by President Obama in 2014 and took office in February 2015 after a 166-day-long confirmation process. Could you tell us about this rigorous process and the politics of becoming Attorney General?
It's a fascinating process. It essentially takes over your life, but it has very little to do actually with oneself. Because most of my record, of course, as a prosecutor was well known. My time in private practice had been scrutinized thoroughly and was well known. I'd been confirmed by the same Senate just a few years prior to be the U.S. Attorney. And so going through the process is one where you attempt to meet the senators on the committee that will be reviewing your application. I spent a lot of time with meetings with members of the senators of the Senate Judiciary Committee, both Democrats and Republicans, to see if they had questions or concerns that I could answer, to talk about the issues, and to talk about the priorities that I hoped to bring to the Department of Justice. And in the midst of my confirmation hearing, the immigration debate was proceeding in the American body politic. Immigration reform had been moving very well on a bipartisan basis with strong support from both sides of the aisle, but it foundered. The legislative reform that I think a number of party leaders, both Democrats and Republicans in our country, had hoped to achieve, they weren't able to achieve. So President Obama decided to act by executive order to put into place many of the mechanisms he had hoped to achieve by legislation and consensus. And what happens when you're in the nomination process and the administration does something that one party doesn't like is that often your nomination can be held up because of that. And so the questions I was getting about law enforcement policy and police reform and criminal justice reform and prison reform all of a sudden shifted to my thoughts on immigration. Now, the Department of Justice has a role to play in the immigration debate because the Department of Justice runs the immigration courts. But there are other agencies that have a much, much stronger role to play in the immigration debate, specifically the Department of Homeland Security. So I would point this out to the senators, and when they would ask about the budget for apprehension of immigrants who were in the country without authority or illegal immigrants, they'd ask about deportation. And I'd say, I'm happy to answer that question. It's actually not within the purview of the Department of Justice, but that's the political process that takes over. And when you go through a confirmation, you understand that it becomes a political process. So you can never take it personally. And I would urge anyone who's going through anything similar not to personalize it, but to recognize it for a process that it is and to determine the best way to move through it. I was ultimately confirmed. I was actually confirmed in April of 2015. And then the policing issues came back in full force because the day that I was sworn in as the Attorney General was the day of the funeral of a young man named Freddie Gray in Baltimore, Maryland. He had died in police custody a few days prior. And it was the night that peaceful protests turned into violence that night. And it was, in fact, the very first issue on which I briefed President Obama.
Along with police brutality, once again, one of the incidents you had to deal with was the Charleston church shooting in July 2015, which killed 9 African Americans. Could you tell us about what you thought this case kind of represented about race relations in the United States at the time, and also the investigation that stemmed from it, leading to the eventual conviction of Dylann Roof?
Yes, yeah. Dylann Roof is an incredibly troubled young man who unfortunately drank the Kool-Aid of the Confederate cause, the lost cause as it is often called, drank the Kool-Aid of those who seek to foment racial discord in the country at a time when, particularly in the South, the races have always lived together fairly well. There have been instances of course, on a day-to-day basis, I should have said, because of course, whenever Blacks have tried to rise from a subservient status to an equal status, they're often met with violence. But the day-to-day interactions tend to be fairly routine, as they are in any society. But Dylann Roof became convinced that a race war was needed of some sort. And he took this legacy of hate that still lives in our country to this day to the Mother Emanuel Church in Charleston, South Carolina. And as those who've studied the case know, he picked that church because it did have historical import. It's one of the oldest Black churches in the city of Charleston in the state of South Carolina. It had a history of being involved in community issues and issues of social justice and equality. Its minister was young and charismatic and dynamic and very involved in uplifting the Black community. And he viewed that as a threat whether to his existence or his perceived way of way the world should be. It's hard to say. It's hard to get inside the mind of a white supremacist and try and explain what they feel and what they think. But what Dylann Roof chose to do was to go into Mother Emanuel Church during an evening prayer meeting. He chose to sit with the parishioners who welcomed him. He chose to sit and pray with the parishioners who invited him to pray with them and did, in fact, engage in prayer with him in their midst. I think at one point he even said he thought about not carrying out his plan, but decided it had to be done. At the end of this prayer session, he pulled out his gun and he executed them. And that's plain and simple what happened. Now, this is a case, again, where the state of South Carolina, of course, had a very strong interest in prosecuting the case, as did the federal government, because of the civil rights and hate crimes issues that were there. So we worked very closely. We had a lot of conversations with prosecutors at the state level about how their case would be structured and whether or not there were still federal charges that could or should be brought. And we decided that essentially both jurisdictions did have a strong interest in carrying out a prosecution of Dylann Roof. And we allowed the state to go first and then had a federal prosecution and ultimately sought the death penalty against Mr. Roof. And that was a fascinating process. I'm often asked sometimes, what is the hardest part of being the Attorney General of the United States? And there's a number of challenges to the position, although it is a position of great responsibility, but also wonderful opportunity. But I will say that probably the hardest decision that any Attorney General ever has to make is whether to seek the death penalty or not in a particular case. Under our laws, in the federal courts, it is the decision of the Attorney General whether or not to seek the death penalty. One makes that decision with the advice of numerous people who've reviewed the case before you, the prosecutors themselves, career officials who compare it to other cases. And you also consult with the victims. And in a tremendous act of fortitude and grace, the victims' families of the Charleston church shooting approached the Department of Justice and gave us their views, which were not unanimous, but generally that they did not support the death penalty in this case, that they had looked in themselves and found the grace with which to forgive Mr. Roof for his actions, which I found amazing and inspiring. And it certainly went into my consideration and calculation. Ultimately, however, I did feel that the interests of justice that needed to be vindicated, the nature of the crime, the type of planning that went into it, and frankly, the level of hate that went into it, meant that the death penalty was the appropriate penalty to seek against Mr. Roof. And that's where he is now on death row.
Can you think of kind of similar instances to this one where you've had to reconcile what you think is best as a lawyer with the interests of communities and what people around you think is best for them?
Certainly the death penalty is always a situation where you have to take that into consideration. In my term as United States Attorney, I've also consulted with victims' families who have had differing views on whether the death penalty should be sought or not. And some have strongly supported it and some have strongly opposed it within the same family. So I've had to look at it more from what does the system of justice require, and should in fact this view carry the day and we not seek the death penalty. It's always a difficult decision. I think also when you're engaged in law enforcement, the challenge is to make sure that the community understands what you're doing writ large and why you're taking certain actions, because there's always an inherent tension between law enforcement and the community. Law enforcement actions are inherently punitive. They generate a lot of tension. They can be rough. And so I've always found it important to have a connection to the community through dialogue with community leaders or young people so that they understand that when the Eastern District of New York comes into a challenged community or into the Black community in particular, that what we're trying to do is root out forces that are targeting them and that we're not targeting everyone. And that's the challenge of policing in the Black community, but really in all communities. Some people take it for granted that the police are on their side and they're looking out for them. Many people do not. And so bridging that gap is something that I've spent a lot of time working on in my career, making sure that the community knows why we're taking certain actions and that ultimately they can come to see that they are on their behalf and that they are in fact protective of them. And I was always tremendously proud whenever I had a chance to receive feedback that told me that we had been successful in some small measure. I remember having a program in my office as U.S. Attorney. I was giving out a few awards to law enforcement officers who had removed a fairly violent drug gang from a housing project in my district. And I received a call from a community leader who said, I understand that you're giving these officers an award for the work they did. And I really didn't know whether they were going to praise the work or claim that it had also subjected the residents to discomfort and harm. But this community leader said, I'd like to come and give them an award also, because the residents of this housing project want to thank them for them coming in and protecting them. And it was all the way in which we had structured the relationship with the community in that instance that let them see our goal and ultimately see that we were there to protect them. So that's a long answer to your question, but it is the challenge that I think is always there in law enforcement is how do you make sure the community understands what you're doing and why, and that in fact it's something that they can be supportive of.
Going back to what you said about the death penalty, where do you see the future of the death penalty in the United States?
I think the United States is moving towards the abolition of the death penalty. It has been abolished before, but it had been revived several years ago. When I became a young prosecutor in the 1990s, there was no federal death penalty. And ultimately, it was reinstated. And so it is a tool that prosecutors have to use. In my view, it's the ultimate punishment, and one has to be very sure that it is appropriate and that you have the right person. Sadly, at the state level, in terms of how the 50 states have handled the death penalty, we've seen far too many instances of people wrongfully convicted of capital offenses. We've seen them exonerated over the years. And of course, it leads to the question of whether or not those who've already been executed in generations past would have been exonerated also had they had DNA, had they had access to better counsel, had they had access to better appellate advocacy on their behalf. So we see a number of states in the United States moving away from the death penalty and not having it as a penalty. And that is something that influences how the federal government views these situations. One of the things you always think about when you're seeking the death penalty on the federal level is whether or not the state in which your federal district is located has a death penalty or not, because that tells you what the citizens have decided or what they think about the death penalty. And so you'll see it being used very rarely in federal instances. And so I think ultimately a review of the death penalty, I predict, will lead to the federal government again moving away from it. It has not yet. But I think more and more states are moving away from it. More and more countries are moving away from it. And I will say that people can analyze this in any number of ways. Some people analyze it from the point of view of whether or not the state should be involved in killing people as a general concept. Some people analyze it from the point of view of whether or not it's an appropriate penalty for the crimes that is usually imposed and that is usually imposed for. Usually it's a homicide. And some people say that there's an equivalency there, that in fact, if it's a homicide and the person was the principal killer, that it's fair and it matches it. We've seen that it certainly does not reduce the level of homicides in either our country or other countries. So it's not a deterrent. But there's some people who feel that it may in fact be an appropriate punishment, but it is so difficult to carry out fairly and with the certitude that it would require that it's just not worth carrying out. People have different ways of analyzing that, and many in law enforcement feel that it simply is not worth carrying out because of the expense and the time and the effort. And our country, I think, is moving towards that position, although it's not there yet.
Turning now to the 2016 shootings, which took place in a gay nightclub called Pulse in Orlando, Florida, killing over 50 people. To what extent did this represent a different face of hatred and hate crime in the US to what you'd seen before? And could you tell us a bit about your response to it, including the $1 million emergency fund you created?
Yes, yes. The South Florida nightclub shootings were incredibly painful. They were incredibly painful for the community. It was a gay nightclub, and so of course the pain on the LGBTQ community, often a target of violence, often a target of extreme violence, was intense. And so the law enforcement reaction was strong and appropriate. And in fact, we were able to identify the shooter fairly quickly and also prosecute his wife, who had been involved in the planning of this attack, sadly. This was also at a time where we were seeing individuals inside the US borders influenced by radical terrorist ideology, taking it upon themselves to carry out attacks. We typically would call them lone wolf shooters to distinguish them from the more organized groups of attackers that we saw on 9/11 or that we saw coming together to try and engage in terrorist activity, even into the mid-2000s. So that was also part of what was happening in the U.S. at that time. Also, was looking at individuals who were motivated, usually online, by radical Islamist teachings that focused on terror, and trying to put it in that context was very important. One of the things that was important for us during the investigation of that case was to try and be as open with the community as possible about what was happening. It wasn't just that case. You may recall we also had killings in San Bernardino, California, a couple motivated by terrorist ideology and radicalized online, engaged in shooting up the workplace of the husband there. And so to the extent that we could, we tried to provide as much information about the investigation as we could. When the shooter is dead, it's easier to do that. But when someone is in custody and there will be a trial, it's more difficult because, again, our rules of court require us not to discuss a number of things about open and ongoing investigation. So we tried to be open with the community and the country. We tried to talk about these issues. We tried to keep people informed as to what law enforcement was doing at the national level to deal with this increasing threat from the lone wolf terrorists. But it was a very painful time. I went to Florida and met with the families of the victims and listened to them and heard their frustrations in not being able to claim their relatives' bodies for a number of days, their frustrations in not knowing in the first few days after the incident what was happening and who would be involved in investigating it and what the motivations would be, and just heard their pain, the pain of losing a loved one. It is the same, whether they are lost to terrorism or organized crime or gang activity or any kind of random violence. It is an incredibly painful process, and it's important for prosecutors to listen to that and hear that pain as well.
Mm-hmm. Turning now to United States versus State of North Carolina, the 2016 legal case, in which you took on North Carolina's bathroom access law, which was eventually dropped after a compromise reached in 2017. What was this compromise, and how do you respond to the criticisms leveled against the Department of Justice for dropping the case?
Yes, it was called the Bathroom Bill, and it was promulgated by my home state of North Carolina. And essentially, North Carolina has been for years a state that has gone back and forth between being fairly progressive on issues of social justice and equality and then swinging backwards into some very conservative and regressive views. And one of the cities in North Carolina had passed an ordinance saying that you could not, it was an anti-discrimination ordinance, saying extending protections to all marginalized people, not just people who were discriminated against on the basis of race or gender or background or religion, but also the LGBTQ community, which as a community faces discrimination and danger. And in response to that, the North Carolina state legislature passed a law saying that was aimed at saying that you actually cannot pass anti-discrimination bills. And in fact, when it comes to members of the transgender community, that they would have to use public restrooms based upon the sexual identity assigned at birth, as opposed to the identity with which they identified or had been living, in many cases, for years. And this is an example of discrimination being couched as some sort of security measure passed by law, because the stated purpose was the protection of young children who might go into the restroom and be confronted with someone who would seek to do them harm. But there's no evidence, and there never has been evidence, that the transgender community has used their transgender status when they're seeking to engage in a very private function as a cover to somehow harm young children. They're not connected to pedophilia. The situations where you do have individuals who target young children and have followed them into restrooms, they have not been members of the LGBT community who have been the perpetrators of this. They have been pedophiles. And that's been, and the law enforcement response should be focused on that. They have not tried to disguise themselves in some way as a member of the opposite sex in order to gain access to victims. So this was a solution without a problem. And it was clearly designed to pacify people who were afraid that members of the transgender community were also being given equal rights under the law, and who were acting out of fear, frankly, fear and ignorance. We contacted the state of North Carolina and told them that this bill was, in our view, unconstitutional, and that to the extent that they were receiving federal funds, particularly the university system, that we in fact had jurisdiction federally, and tried to work with them to get them to modify it or repeal it. At that time, the leadership in the state declined to do so, and we said, we've been very clear, this is unconstitutional, and we will use the courts to seek redress. And so I did in fact bring a lawsuit against the state, the governor, and the University of North Carolina school system. What happened in 2017, we were prepared to go to trial on that case, by the way, and we were convinced that we would prevail. What happened in 2017 was the statute was modified in some ways that made it much more ambiguous and rendered a challenge a little bit more difficult. Not impossible, in my view, but the administration that followed mine did not feel it was a case that they were going to pursue.
Turning now to the 2016 investigation into Hillary Clinton's use of a private email server, you were criticized for your perceived role in this investigation surrounding the Secretary of State's actions, centering around a meeting you had with former President Bill Clinton at Phoenix Airport. You acknowledged the perceived conflict of interest that arose from this and agreed to accept recommendations from the FBI. Could you tell us a bit about the impact this had on your time as Attorney General and on your career?
Well, I find it fascinating that people still bring this up, and I'm glad you did, because it gives me a chance to actually clarify what actually happened. The reality is I had very little role in the case and the investigation into Secretary Clinton and others' use of how they handled email while they were at the State Department. And in fact, it was handled by career prosecutors and agents throughout. I did see President Clinton at an airport. He did come on my plane to say hello to me. It was a totally unplanned encounter, and it had nothing to do with the case whatsoever. I would correct you though. However, I did not step aside from the case. I immediately consulted with ethics people at the Department of Justice. I did not say that I would accept the FBI director's recommendation, nor did I accept his recommendation. The FBI director chose to step out and make his recommendation public about a week after that incident. And I think he led people to believe that it was as a result of my having spoken to the president. But as subsequent facts have shown, he had been planning to do that for months prior to that encounter. And he had his own reasons for doing so. I think he thought he was somehow protecting the independence of the FBI. But of course, it did not have that effect. It muddied the waters tremendously and generated a lot of attention on statements he made that were not very clear in terms of the legal basis for how the case was going to be decided. So again, and as I said in public statements at that time, I did not step aside from the case. I maintained my position as the leader of the Department of Justice and convened a meeting and heard from all sides who were working on that investigation, not just the agents who actually do not have the authority to decide whether a case will be prosecuted or not, but from the lawyers who had done the analysis, done the comparison to other cases, prepared a very thorough and detailed legal analysis that unfortunately the FBI director did not take advantage of and did not even reference in his comments. And so based upon the legal analysis provided to me, I actually accepted their recommendation that it was not a case that was going to be prosecuted. Most people who've looked at that case have come to the same conclusion. There's been endless scrutiny on it, as I'm sure anyone who's read the papers at that time knows as well. I mean, I've heard journalists talk about their coverage of the 2016 campaign and say that they regret giving that case so much coverage as opposed to the real policy issues that were there. But that, of course, is for them to deal with. So for me, it was frustrating, I think. But again, part of the election cycle is that issues will come up and they will get seized upon in the political process. And that was very much a political process. My job was to try and keep the Department of Justice out of the political process by making sure the case was investigated and handled as any other case would have been, that it was researched thoroughly, that no stone was left unturned, and that we were comfortable as a matter of law and policy, and also looking at similar cases in the past in the decision that we all came to, that this was not a case that was going to be prosecuted.
You stepped down as Attorney General as President Obama left office in 2017. What do you see as some of the most significant achievements or accomplishments of your time in office? And when you look at Attorney General Sessions and Barr as your successors, do you see some of the progress you made in this time unraveling under them?
One of the things I was most proud of as Attorney General was being able to work on the issue of law enforcement and community relations. As we've discussed, it's something that I've been working on since the 1990s when I became a prosecutor, and I have not stopped, even in private practice to this day. So I was tremendously grateful to be able to work with a dedicated team of people who reached out to law enforcement. We offered support to police departments across the country. They came to the Department of Justice seeking guidance, seeking grant funding, and seeking assistance with policies that would prevent them from going down the road that they saw cities like Ferguson, Missouri, Baltimore, Maryland going down in terms of use of force and poor community relations. And also there were a number of police departments that were not able to make that transition well. And so we had a very robust what we call a pattern and practice division that looked at these police departments to determine whether or not they were engaged in unconstitutional policing. And even there, we worked tremendously hard to make those investigations a joint effort, along with community members and police departments, to try and find out what are the issues that are keeping this particular police department from being the best that they can be. Sometimes it's police leadership and police culture, endemic and systemic racism. Sometimes it's incredibly poor training and a view that officers cannot show fear, they cannot show compassion or empathy, that leads to this break as well. Trying to empower the community to be involved in police issues as well. So I was very, very proud of that work. As I mentioned before, my tenure began with the death of Freddie Gray in Baltimore, Maryland, and the tremendous pain that spilled out onto the streets of Baltimore. I picked up the Ferguson investigation, which began shortly before I became Attorney General. And we did a review of that police department as well, and found not just systemic problems within the police department, but a municipal system that was set up in a way that relegated Black citizens to a second-class citizen and placed on their back the economic burden of supporting the town. Incredibly high fees and fines imposed mostly on the poorest residents, but they were counted on as part of the revenue of the town. So not just policing issues, but how the way that government interacts with the citizens writ large contribute to these issues, and in fact are often the root causes of them. It was a very, very important part of my tenure as Attorney General. And I will say I've been probably most disappointed that the next administration turned away from that work. The next Attorney General decided to suspend the pattern and practice investigations. He actually sought to reverse the consent decrees that we had been able to generate, again, on consent of the parties, clearly outlined evidence-based, data-based methods of improving police-community relations, providing support for police training and accountability. He sought to overturn those. He was denied by the courts in the relevant jurisdictions, but made it very clear that he didn't think that the federal government had a role in police oversight. I believe that was a mistake. I believe that we are seeing today in the current efforts, the current issues around policing, 3.5 years later, that it was a mistake for the Department of Justice to turn away from that work and not be a source of support and, in fact, a bulwark for communities as they face this difficult issue. And that's been the most painful thing to see that people have needlessly suffered when the federal government that we take such pride in this country, that in fact only exists by the consent of the governed, has turned away from an area and a situation of such incredible need. And I can only hope that recent events, as painful as they have been, will convince the Department of Justice that they have indeed a vital role to play.
Turning now to these recent events, as you said, we record this interview in the wake of the murder of George Floyd by Derek Chauvin of the Minneapolis Police Department, which you've described as an abject failure of policing all around the country. 2 days ago, Minneapolis City Council vowed to dismantle the city's police. What do you make of this decision, and what does it mean for safeguarding in Minneapolis?
You know, the Minneapolis Police Department is indeed a troubled police department. Ironically, they were one of the police departments that initially reached out to the Department of Justice around 2012 and 2013 when they got a new police chief, and they sought help. They said, we need some guidance on excessive force policies. We need some guidance on disciplinary issues and how to handle disciplining police officers within our department. And it's a process called collaborative reform, where the Department of Justice under the Obama administration would work with departments that came to us and, in fact, connect them with police consultants, often former law enforcement themselves, connect them with other police departments that had been through these challenges, and give them a blueprint for improvement. And that's what happened in Minneapolis. Unfortunately, they chose not to follow the blueprint. They adopted less than half of the recommendations. They did adopt some. You know, I want to be fair to them. You know, some of the recommendations that they adopted are what allowed them to fire the police officers involved in Mr. Floyd's death so quickly. But they didn't adopt all of them, and particularly in terms of how to discipline officers and making those disciplinary records transparent to the community, and also in terms of training. And so you see that this is something that has to be continuously maintained and adopted. And so, of course, the Minneapolis Police Department, after they'd gone to the Department of Justice, even before Mr. Floyd died, they had the tragic death of Philando Castile, who was killed during a traffic stop by an officer. Mr. Castile is sitting in the car. He tells the officer that he has a licensed firearm with him, so the officer is aware of that. And as you watch that particular videotape captured on a dashboard camera, you can see that officer reacting in fear and shooting Mr. Castile in the front seat of his car. He was tried. He was acquitted of that homicide. So again, you saw very little accountability for the loss of Black life in Minneapolis. You also have Minneapolis as a city that ranks very high in a number of demographics of livability for white citizens, but almost at the bottom in terms of demographics of livability for Black citizens. The home ownership rate is very low. The rate of the ownership of Black businesses is incredibly low. And so you have a very, very divided society and a city. So what you have there in terms of the failure of policing has been the failure of the Minneapolis Police Department to take appropriate steps to bring themselves up to constitutional standards, to listen to the community, to involve the community in how they are run. So the Minneapolis City Council has said that they will disband the police force as they know it and reinstate a public safety system under different standards. They haven't outlined that yet. I and so many other people are waiting to see what models they will look to. It has been done before, in fact, and you have cities such as Camden, New Jersey, that had a very challenged police force with an incredibly negative relationship to the Black community. And every time Camden tried to change the institutional systems that created this relationship, they were met with tremendous resistance from the police union and also some citizens. So Camden dissolved their police force and created a new public safety department that carries out police functions, I do believe that at the end of the day, there will be public safety officers in the city of Minneapolis, whether they're called police or public safety. There will be those who are charged with protecting and serving the public and protecting property and coming to aid if someone is trying to harm the citizens. There will be a structure for that. How they will handle the other issues that also challenge police departments today, which is how they will handle issues of mental health and homelessness, remains to be seen. They may in fact move those functions away from the police, which I think would be frankly a positive thing in many communities, and place them back in that public health sector where they can get more appropriate resources and care. So we'll have to see what structure Minneapolis comes up with, but they do have a number of models to go by. I do believe at the end of the day, as I mentioned, there will be a public safety force in Minneapolis that citizens can turn to for protection. It is my hope that it will be done on the basis of the strong community policing standards that have been proven to be effective in both having a positive relationship with the community and reducing crime. That's my hope.
Thank you. Our final question today comes from Louisa at Wadham, and she says, after seeing the police brutality and huge disenchantment and absence of faith in the US when it comes to the police, are you left with any optimism for the future of policing in America? How does the 2020 election feature in this?
Well, I'm often asked this question, am I an optimist about policing in America? And I have to say, ultimately I am. I am, because people are protesting. People are speaking out. They are raising their voice and they're making their demands very, very clear. And they're pushing their elected leaders to act upon them. Change is happening. We have seen a sea change in the position of most of the country on whether or not police brutality is even a problem. A majority of Americans now see that it is. Just 10 years ago, a majority of Americans did not think that it was, because it didn't affect them. It didn't touch them. It didn't touch anyone that they knew. But now that they have visual proof in front of them, and it is a tragedy that it takes that, but this is where we are. We see this change in the thinking of most Americans. We see a refusal to accept the old methods of policing with the concept of a police officer as the warrior. We see a demand for the police officer as a guardian of the community. So I say I'm optimistic because people are raising their voices, they are protesting. And if people didn't care, they wouldn't be speaking out. And people care very, very deeply about this issue, and they are making their voices known. It's having an impact even before the 2020 presidential election. Municipalities are enacting laws that we have been trying to get them to do for years, limiting qualified immunity for police officers so that there can be redress in civil court as well, making disciplinary records public so the citizens can see the nature of the people whom they are entrusting to guard over them and their families. So a number of locations are passing these laws, and frankly, banning chokeholds, a police structure and device that has never generated the kind of success that you would expect, given how often it's used. It is often used to fatal ends. It does not keep communities safer. It does not give people confidence in the police, and it generates incredible distrust and mistrust of the police. A number of jurisdictions are already banning chokeholds and other types of neck restraints. At the federal level, we're seeing discussion about whether or not that and so many other measures can be done as well. The focus on making sure that there's training, that there's accountability, that there's transparency. All the things that we were talking about during my tenure as Attorney General are now part of a national conversation. And that makes me optimistic. It really does.
Thank you so much, Attorney General Lynch. It has been a pleasure speaking to you. Thank you for joining us.
Thank you for having me.